Right. So my name is Max Chowdhury from Chowdhury Law Office, and if you've seen the video link, you'll know that I've been in the practice as a lawyer for immigration law for Canada during the past 28 years. And if you have a question, then this is a venue where you can pose the question. The idea is that online there are various sources of information, such as immigration forums and chat groups and the immigration website itself. And sometimes these sources don't have suitable context for the question, or perhaps the immigration website or these online forums are characterized by very specialized terminology, which leaves you not being able to see the forest for the trees, for example. So with that in mind, periodically, I want to give an opportunity to, in a somewhat cost-effective way, give you a venue where you can, for example, double check what you may have found online about information about a program or things of that nature. And so from that point of view, I want you to feel free to pose a question. Just one already from Mr. Aurora. And so this relates to the fact that an application for a citizenship grant was submitted on March 22nd, 2021. The application number, which is associated with the acknowledgement, was received May 31st, 2021. And Mr. Aurora looked at the current processing time for the citizenship application, and it's 18 months. And that's clearly well over the time frame in which that application was submitted. So oftentimes with citizenship, we always want to eliminate the obvious, which is, for example, sometimes there is a delay in getting a third-party document like a police clearance, sometimes from a country outside of Canada. So if that has been submitted, and if everything else has been submitted, then, and I'm assuming if sometimes there is the oath takes place, or not the oath, but rather the test for citizenship takes place, and then nothing happens. And that's those pieces of documents or events, such as the citizenship test and police clearance, are associated with you, the citizenship applicant, delivering everything you possibly could from your side. And that's very important, because if you have a combination of published processing time that has been exceeded, namely 18 months, as my understanding is from the CIC website, and if you have submitted all of the documents and then the requisite time frame has elapsed, then really after this, and I see there's a comment that the test was actually given already, and there was a duplicated request for fingerprints for some reason by the immigration department. And then the premise behind seeking some other kind of relief besides the routine web form, which I'm assuming everybody would normally do, then what you have to explore is as you might have heard of, if you Google it, is mandamus. So mandamus is when there is essentially a public duty on the immigration department to process the case. And the context for that is that there has to be what's characterized as an unreasonable delay. And in many cases, if there is a published processing time given by the immigration department and it has been exceeded and you filed everything required from your side, then, and if there's been no response to a web form request for status, then you may have no other choice but to consider a mandamus, which is a request for relief from the federal court. That request has to be preceded by a formal demand of the Immigration Department to process and finalize the case within a certain time frame, perhaps 30 days or something along that nature in terms of time frame. And then once you submit the formal demand letter to make a decision within 30 days, if that time has elapsed, then you can proceed to federal court and make an application for a mandamus. And hopefully that will take 3 months if the case is obviously, by any objective standard, unreasonably delayed. In the worst case, particularly if the government lawyer, namely the Department of Justice, contests the mandamus application, then you would be facing, or the opposing lawyer would be filing arguments against the memorandum that you, or your lawyer more particularly, would file. And that would necessitate a need for a reply, and then a federal court judge would look at the papers that are filed and then make a decision if the party should try to negotiate, or the federal court judge could demand a hearing. And in that case, the case could take more than 8 months. So that is a thumbnail sketch of one scenario to deal with what might be an unreasonably delayed application for citizenship. So that being said, for anybody who has joined recently, feel free to pose a question in the chat, as I see Mr. Aurora has done, and I will do my very best to endeavor to respond to your question. Ideally, when people pose a question, it's good to get a little bit of context. We try to do the best we can when there's a very general question. These types of queries are kind of like, for example, when I see a query as it's phrased here in the chat, it's kind of analogous to what we see in an email. And if at all possible, we try to get a bit more context from the people who may have emailed us, our office, to try to, well, firstly, give a suitable audience for people who email us at our office, so that we can endeavor to answer a question. And by analogy, it's a kind of similar process here when where we cannot, by definition, we cannot get a full context to what a person's issue is. So the type of response I give in this forum, like an informal webinar, is not meant to be advice, but rather one possible course of action. So I'm not advocating to do what I've just said, for example, because there could be some subtlety missing in a delayed application case, which can run the gamut of any kind of application, from a delayed visitor visa to a delayed sponsorship, or as in this case, a delayed citizenship application. So there's a follow-up question from the same person who asked the question about delayed citizenship. And this is sort of what I would characterize as the minutia, or the nuts and bolts of an application, in this case, a citizenship application. And that relates to, what do you declare, specifically when a citizenship or other type of application asks for type of question. So in this case, based on the question being posed, it talks about personal history. So the general rule, And this I would say applies to relatively innocuous things. The general rule is to disclose as much as reasonably possible. In the citizenship context, keep in mind that they want to be satisfied that you are physically present in Canada. So, in that case, it's to your advantage to disclose more detail about your personal history. Namely, if you were employed in Canada, then you'd want to say, as part of your history, you were employed in Canada. Obviously, in some cases, that's impossible. For example, if a person is a student, they would put student, or if they're unemployed, they would put unemployed. So, subject to certain exceptions, which would probably require a paid consultation, the general rule is try to be as specific as possible. So that's, again, lawyers are always couching things with exceptions. So I've stated the exception, and I don't think I need to repeat that, right? And so the other question is probably related to potentially forming a lawyer-client relationship. So just to deal with that is we don't do U.S. immigration law, but if you reach out to us, we're in touch with a couple of lawyers who do practice U.S. immigration law, and that would be ideal, right? For just to ensure that you're getting the best possible advice for the service that you may actually be seeking. So there's another question posed just now, which is what is the duration it takes to get a decision on a TRV after submitting the biometrics? So this question is factually driven. So in terms of the context, you'd have to disclose the country of ordinary residence where the applicant is living. And that's a very specific term. I did not say country of citizenship because in some cases, people who are applying for citizenship, they may have citizenship in India, but maybe working in the Persian Gulf. And then that could have an effect on, for example, which Canadian visa office is dealing with the TRV application. So when I last looked, perhaps 2 weeks ago, if the person was in India, I think the website officially said something quite short. I think it was maybe 30 days. But then there's intervening circumstances which have an effect on this, such as the kind of diplomatic breakdown between the Indian government and the Canadian government. And that has the effect of consequence from expelling officers, which could inevitably lead to delay in a TRV application. So anecdotally, when somebody files for a TRV, sometimes they will get a request for biometrics maybe 1 day after it's filed, and sometimes it's 30 days. We see no logical pattern to this, except that there is no pattern. So sometimes people try to obtain some clue about how much time is remaining on the processing of a TRV application based on when the biometrics is received. But unfortunately, it's really hard to say. The immigration policy is trying to streamline TRV applications by using artificial intelligence and by even opening up the amount of countries which are TRV exempt. So I believe in the summer, a lot of Caribbean countries, not all of them, but a lot of them had their requirement for a TRV lifted, and they simply need an ETA. So these are the factors clearly affecting any kind of application. The fact that they're opening up TRV exempt countries using artificial intelligence as well to try to triage these huge amount of volume for TRVs, which also can encompass, broadly speaking, study permits and work permits. And anecdotally, there's something of a hierarchy in terms of what they want to prioritize, namely study permits, because that is apparently a de facto revenue stream for provincial governments to fund their colleges and universities. So that gives a little bit of context to the variation in TRV processing. Another factor which may affect an individual TRV is if they have some admissibility issue. But unless somebody poses a question about that, then I won't really get into that, since there is another question that I'm seeing here, right? And if I try to do this by order, and I try to read the question out loud just to give me a sense of what it's saying, is a day of a Canadian citizen, how long does it take to bring his or her spouse to Canada? So I'm going to presume that's to bring a spouse as a visitor. And I'm going to make that presumption for now, because there was a program, I believe in May of 2023, which opened up the option for people who are engaged in sponsoring a common law partner or spouse to have their spouse come to Canada and even work while the permanent residence sponsorship application is in progress. It was touted, I believe in May or June of 2023, as being a very fast process. We haven't had any luck in our office with the one or two outside of Canada spousal sponsorships having the TRV expedited based on the policy. So I don't know if that's simply our office, or maybe it's not a sufficiently large enough sample size, since we've only had two outside of Canada cases for spousal or common law that are processed. But if you do Google diligently, and everybody seems to do that, the promised processing time is supposed to be expedited. The presumption in expediting the application is that there is a fully formed spousal sponsorship application, and that is in the system, and that can give a clue to the officer who's tasked with the TRV about the genuineness of the relationship, which should put the other officer who is tasked with the temporary application to bring the spouse at ease that the person won't be going underground or won't be in non-compliance of the requirement to be a temporary resident pending the outcome of their spousal application. So I'm hoping I've answered that question. And the next in the sequence relates to an economic class application under express entry, where the candidate has received the invitation to apply and the required police clearance has been filed for. And there's a specific question about, can the application be submitted with the proof of tracking of the police clearance by the third-party company, which I don't know the acronym, but it's BLS, which does Indian police clearances. So it's you have to keep in mind the Immigration Department's view of express entry. So number one, they're touting a fast processing time of 6 months for that system, primarily because it is an e-application system, and a lot of the criteria is objective. So it's not as discretionary on the part of the Immigration Department. It's more like quality assurance. So the amount of scrutiny for ITA-based applications is, by definition, usually pretty light. The most you'll get is maybe a phone call, maybe to your employer, to confirm the work permit duties, or to confirm that you actually work there, for example. Or maybe they'll just call you, or they'll give you in other cases we've seen, they'll give you 7 days to respond. If they did contact your employer and say that the employer didn't answer or the employer had no idea who you were. So those are examples just to emphasize that ITA-based applications are supposed to be fast. And so putting that in context to this question, which is basically, should I put the tracking number proving that the PCC is in progress, or wait for the PCC itself to come? Prudence would say that you should try to do both. Put in the tracking number, perhaps through a web form, and then similarly, once it does come, make sure that it is submitted before the usually 60-day deadline for the entire application for the e-application for permanent residency. So it's kind of like a precautionary method. The one thing to keep in mind is that if there is a policy from time to time that says, in some cases, you can extend the normal 60-day requirement for a PCC. I have not looked up if that policy has been revoked. That policy seems to come and go since Express Entry was invented in 2016. So if you're stuck, you should apply for an extension of time, whether or not there is that policy in effect. The policy has the effect of making it easier for the extension of time to get a PCC to be higher, as opposed to when there is no ongoing policy issued by the Immigration Department. And so I'm looking at the other question, which is a relative from Sri Lanka wants to come to Canada, has employment in Qatar as an electrician for a number of years, and then wants to transition from visitor visa and then work permit. And then the request is to give some thoughts or context to this. So the caveat is that the level of English and French is not fluent. So as you might know, if you look at the Express Entry system, the points are designed so that you get an extra 50 points in most cases. In some cases, 200 points if you have a certified job offer. So there is a policy right now, which is in effect till 2024, that if a visitor comes to Canada and is offered a job on a closed work permit, they could apply for the work permit while in Canada. And that's not the norm, particularly before COVID-19. The person would have to apply at an outside of Canada visa office to transition from a visitor visa to a work permit. But keep in mind what I just said. It's a very narrow category of work permits, a closed work permit such as a LMIA or Labor Market Impact Assessment based work permit. And LMIA means that the would-be employer has been scrutinized by ESDC Canada or Service Canada. And that scrutiny is characterized by, for example, the would-be employer advertising in 2 or 3 venues for 1 or 2 months to show that hiring a foreign national would have a neutral effect on Canada's labor market for existing permanent residents or citizens. So it's important to keep in mind that there's a little bit of a task to be carried out by the would-be employer. To provide a bit more context to this, if there's a situation where the person does not speak English well, then you're looking at a very narrow kind of circumstance from the lens of the would-be employer, where they cannot find somebody in Canada with a certain skill, but the skill that the would-be employer requires does not need to have fluency in English, but may need to have some other kind of skill, which is not readily available amongst workers who are already entitled to work in Canada, such as permanent residents. So again, that's when I state these caveats, namely LMIA scrutiny, and then a very specific type of work skill where something technical is required, but at the same time, level of language is not required. I could speculate that could be something very specific, like heavy diesel repair worker, where they're like large industrial size machines where the machines are maybe in remote parts of Canada, like in northern Alberta, and arguably there could be a situation where the candidates, there are no Canadians who are able or willing to relocate to a mining town in northern Alberta. And then in that situation, if the candidate outside of Canada has very specific skills that the Canadian employer cannot find, then maybe their language is not essential, because that type of job does not require sophisticated correspondence on a day-to-day basis. It's really just reading a manual and then applying your previously acquired skills as a heavy industrial mechanic to repair a device, for example. So that's sort of the best case scenario I can put out there in terms of who could really come to Canada and transition from visitor to worker. And then subsequently, working for 1 year in Canada may allow you to apply under the CEC class, depending on your age. And everybody lives happily ever after. So if I just proceed to a related question, or the subsequent question, which is sharing information about parents' sponsorship, and when it will be opened, and the current state of affairs, which is they're doing 2020 cases. So this is, generally speaking, the question as posed has the facts correct. They have opened up parental sponsorship, but only people who have been in the pool that was formed in 2020. So traditionally, there are, when the amount of parents being eligible to file for permanent residence under the family class was higher, then there would be an expression of interest once a year, and then there would be draws twice a year. And I think that state of affairs was from 2016 until 2019. And it was random. I believe before 2016, it was first come, first serve. So, I mean, that's just sort of the context. But for the purposes of this question, the fundamental element you should know is that the program exists in the regulations, but the amount of spots available are low. And for whatever reason, they've only restricted it to the last pool that they have invited, which is from 2020. And we see people in the recent past approaching us saying, I've got an invitation now. And they were, as is consistent with the policy, doing the filing their expression of interest in 2020. So for the foreseeable future, the Immigration Department is completely silent about when they're willing to have invitations for new expressions of interest for this parental lottery. One clue is not encouraging, which is the fact that they've upped the amount of time for the duration on super visas for from 2 years to 5 years. So that's kind of throwing a proverbial bone for people who want to have their parents stay on a longer term basis, because 5 years is an incredibly long time based on the typical duration of visas issued by the Canadian government, which are typically 6 months to 2 years. So that's not a good sign if you want your parents to someday have access to a pool and family sponsorship, unfortunately. All right, so that is the longish answer I've given to the question. And if I look at the subsequent question, a situation where there is an early childhood educator candidate for some application working for the Young Man's Christian Association as an RECE and completed working hours. And the question is whether it's suitable for permanent residency. So one thing to keep in mind is there's a broad distinction between it's forming sort of morphing into two types of categories, and one is the traditional economic class under CEC and FSW and federal skilled trades, where there's a tier level acceptable of 1, 2, or 3, which is the skill level essentially. And then there are slowly other programs where the skill level may not be as high, such as personal support worker. And I'm not sure if the required duration for early childhood educator is a NOC tier 3 level or not. My presumption is it probably is, because you're dealing with children. The concern is that if the early childhood education requirement is less than a year, then it may not be a traditional FSW or CEC application, but rather maybe a targeted application under one of the provinces where there is a shortage of certain types of workers, like truck driver and other lower skill jobs. Or it may be a situation where there is the pilot project for people who are caring for like high required elderly people or people who are caring for children. And those are time sensitive pathways to permanent residency, which start as a work permit first. And the amount of spots for those are quite limited. And I believe the caring for children class, when it opened at the start of the year, it finished and it was full literally in a couple of weeks. And I believe the related program of caring for elderly people that was open and closed, I believe, in April or May of 2023. And those are a pathway to permanent residency, starting with a work permit and then working, and then you can even bring your family under those programs and then come to Canada and apply for permanent residency. Anecdotally speaking, those programs, although they do open up another pathway for people with those types of skills, anecdotally, the processing time for the work permit is quite long. So, but that being said, it's the only opportunity for those people who have those types of skills. So I'll try to proceed. This seems like a very specific question about skills. So a medical doctor who is a virologist and is employed in a government hospital in Bangladesh. And the question is whether a job can be directly sought in Canada for employment. So if you recall my earlier answer about transitioning from visitor to work in Canada, the overarching premise for a foreign national to gain work in Canada is that it suits the predominant purpose is that it does not disturb the labor market for existing permanent residents or Canadians. And to a lesser extent, there are some public policy exceptions to that. Like if you're a work permit holder, you can bring your spouse on an open work permit. And that's deemed to be not really affecting the eligibility for Canadians to compete in the labor market. But in this case, where there is a medical specialist who is gainfully employed already and presumably has demonstrated work experience in the form of a work reference letter from a credible organization, namely the government of Bangladesh, that could arguably be the foundation for a work permit if, for example, there is a shortage of virologists or maybe a subspecialty of virologists in Canada. And recourse for that or research for that can be had in the Canadian official government job bank. I believe it's jobbank.esdc.gc.ca, but don't quote me on that. I'm just going by memory, but just look up Canadian Government Job Bank. And that could be an avenue where you could discover that there is a job opening for a virologist or a subset of virologists who have a specialty in a certain type of virus or something along those lines. And then in that scenario, because we live in a world of COVID, arguably it should not be that difficult to get the job offer certified by the institution in Canada if they're having difficulty finding somebody in Canada with those skills. And that would lead to, the LMIA would lead to a work permit application. Supported by an LMIA, the candidate applies for the work permit with the LMIA in hand, and hopefully the processing time is not too short. And then everybody's happy, the employer and the putative worker who is a virologist. So another question relates to something of practice, sort of nuts and bolts, granular element to a work or PR application, which is what is the reference letter format from a home country. So you want to keep in mind the sort of obvious purposes for the work reference letter and then go down from there. So the obvious purpose is to confirm employment and work duties and create enough detail to show the work duties that are performed. And similarly, you want to have sufficient coordinates for the immigration department to contact the employer if they have expressed some concern. And then there's a kind of subset of sort of aesthetic concerns, which I've seen come up in my practice when I've reviewed officer notes for people whose cases were refused. And sometimes the concerns are essentially, for example, candidate one has submitted 2 work reference letters. The font is the same, the structure is the same, the letterhead looks the same, but they're 2 different employers. This looks fishy. Let's contact the employers. The other concerns are where, for example, the job title and the work duties seem to be at odds. Another situation is where the work duties are insufficiently described. And sometimes there's certain commonsensical things which come up, like it's not dated, like there's no dates, so then there's no context, right? Unless maybe in the subsequent part of the letter it says the candidate started work on such and such a date, and then maybe that would not arouse suspicion. And it's always good to have the sort of tail end of the letter contain, so obviously like a signature block. And in the particular case now with COVID, there may not be a need to have it signed traditionally, like with what's called a wet ink signature, but some other kind of verifiable identity, like I think is suggested in the question itself, like some form of electronic stamp by the company. Arguably, in the realm of COVID, where many white collar workers are still working from home, perhaps 2 or 3 times a week, and given the increasing ability to scrutinize electronic documentation with third-party verification, it should be acceptable in the vast majority of cases, as long as it's corroborative. In other words, the immigration department can look up sufficient details of the author of the letter to double check, to ensure that the electronic stamp as a substitute for a signature is buttressed by contacting the employer. So if I could just move on, the other question relates to the time frame it takes to renew TRV from the United Arab Emirates. And I don't know offhand the ordinary processing time, because I have what we call, some people call Google Foo. We look up extending a TRV from outside of Canada. And if you're ordinarily resident in the United Arab Emirates, for what it says on the IRCC website, it's 140 days to apply for or renew a TRV. One thing to keep in mind about those processing times, I don't know if it still explicitly says it, is that the processing times are meant for 80% of cases. So that's just a fancy way of saying that there are certain cases which are subject to more scrutiny due to admissibility or due to a previous refusal. And those 20% of cases would not be benefiting from the published processing time of 140 days. So it's something to sort of contextualize when looking up the processing time, and manage your expectations accordingly. And then you may have to seek mandamus if you really, really need to come to Canada, which is something I posed, or that was posed to me earlier in this discussion. And another specific question, we're sort of running a little bit towards the end here, is if somebody is sponsoring a spouse and the application is commenced, is it wise that the person should apply for a visitor visa for the spouse? As I might have touched upon, or as the person posing the question may or may not have heard, I did mention the policy, which is encouraging people who are filing spousal applications to have their applicant/spouse file for temporary status in Canada. So in a case where this is where what the concept of dual intention is at play, where on the one hand, you're filing for permanent residency to live in Canada permanently, but at the same time, you want to temporarily reside in Canada by filing a spousal application, but simultaneously file a temporary application. Under the law, I believe Regulation 22 of the Immigration Refugee Protection Regulations, dual intention is allowed as long as you show that you're going to comply with both applications, the requirements of a temporary resident and the requirements for permanent residency. So the short answer is yes, you should try to apply, right? And I think there's perhaps another question here, which is, can a person travel out of the country after submitting the ITA due to an urgent matter? Oftentimes, ITAs are connected to the three main categories: CEC, FSW, or Federal Skilled Worker, and Federal Skilled Trades. To my knowledge, those programs do not require the need to remain in Canada, because in a sense, the work experience you've filed in support of those applications has already been locked in. So there should be no impediment for leaving Canada after you've filed a complete EAPR, a complete E-application for permanent residency under one of those categories. So keep in mind, though, you have to maintain some kind of status to return, such as a TRV and or work permit or visitor visa, as the case may be. So it's also good if you're needing to renew your TRV to re-enter that you have proof of the medical emergency when filing for the TRV and proof of compliance in the past with your previous status in Canada as a visitor or worker, as I probably think is the scenario for that situation. So we're coming up to the home stretch in terms of the hour I've allocated for this Q&A. I think I see a follow-up question, which is, do I need to write a letter to explain my travel? The question for that really relates to, I'm going to arbitrarily presume that the the letter to explain would be to support the future TRV to re-enter Canada. And it's always good to give context to the officer, especially when it's a temporary visa where the criteria is quite discretionary and sometimes relates to your previous immigration interactions with the Canadian visa authorities or even other countries' visa authorities, such as whether you've had a refusal for some kind of status in some other country. So a letter is good. And keep in mind, it's a discretionary application, but if you have a good track record with a previous discretionary application like a visitor visa, then the likelihood for success for another visitor visa should be somewhat higher than average. So just something to keep in mind for keeping thinking optimistically, right? So, and then same poser of a similar question has an additional question. In terms of context, there's a work visa currently. So when I see work visa come to mind, then if I was a immigration officer overseas, I'd want to see that there's an ongoing employer-employee relationship. And similarly, if you have a valid work visa connected to your TRV, then if I was the CVSA officer at Pearson Airport and you land, I'd want to say, what are you doing? And you'd say, I'm working. And I'd say, who are you working for? And you'd say, the company. And then the officer may call the company and say, is this individual still working for you? And then the company would say yes. And they'd say, okay, welcome back to Canada. So that's an example of some type of scrutiny that could occur in a situation where you have to leave Canada owing to an emergency and then want to re-enter on your temporary status. It's just to make sure to satisfy the Canadian immigration authorities that the factual status quo, namely that your ongoing employment is assured when you're re-entering Canada. So that's some kind of context. And another question is, if my TRV is refused, within how many days can I file for an appeal? So the broad rule is that if you are physically outside of Canada, you have 60 days. And if you're inside of Canada, it's 15 days. There's a bit of confusion when you are a person outside of Canada and the refusal is issued by an office inside of Canada. In that case, prudence might say the due date would be 15 days from the date you first received the decision. And Mr. or Ms. Mehta, you're welcome for the responses. And the question is there a recording available? And in this world of marketing through a crap ton of content, then yes, I would endeavor to make this recording available, put it on our channel, and I encourage you to look at our channel. There's substantive videos, and there's lots and lots of YouTube shorts, which have various microscopic questions, and you may find some clue to an issue you have based on the title on the YouTube shorts. I think I've got something like 70 YouTube shorts because that's how we promote ourselves, since there's no longer a book mailed to every house called the Yellow Pages or something like that. So if I go to the next question, it's do we need to write a cover letter when submitting documents for an invitation to apply under Canada Experience class? So I'm not going to read the rest of the question. And generally speaking, it's a good idea just to cover and to reiterate your compliance with the CEC criteria, which is essentially the most discretionary element of CEC arguably may be the work experience. And in some cases, if your history is a bit unusual, then you may want to put a cover letter. And what I mean by history is maybe your history of compliance with any kind of law in any country, including Canada's immigration laws, and you want to contextualize that. The sort of related follow-up question to that CEC question is, do we need to show proof of funds if you're working in Canada? So for CEC, as distinct from FSW or Federal Skilled Worker, you do not need to have funds because you're a safe bet. You're already earning money in Canada. So that's sort of the reason to, if at all possible, try to come under CEC as opposed to FSW. Some people can apply under both because they have work experience outside and they work for Canada, or sorry, they've worked for a Canadian employer inside of Canada. So the YouTube channel, it should be I think something about Max Chowdhury, immigration lawyer. Just look for those 4 words on YouTube, and because I post, I don't we post, and I don't know the immigration, the nuts and bolts of the title, which is somewhat embarrassing, having worked on it for quite a while. But if there's any particular question, you can reach out to Clerk, my assistant, at chowdhurylaw.com if you want us to search up a link for that, or if there's some kind of simple question where we're not in a position where you're going to be expecting that to be binding legal advice, then you could pose that. So one thing to keep in mind for anybody who's remaining here is that don't be offended if lawyers don't answer the question, because our regulator is very concerned about people interacting with a lawyer and then creating what is called a solicitor-client relationship, and then the client is under the impression that legal advice has been given, and then the brief answer which was given to the very brief question lacked sufficient context, and then the client followed the response to that as full-blown legal advice without providing sufficient detail to the lawyer, and then something blows up in the client's face, like they're at the port of entry at the airport and they're being told that, no, you can't come in, and then we're going to send you on the next flight back to Hong Kong or New Delhi, as the case may be. So don't be spooked or offended by that. So that's why my assistant tries to be helpful, but we can, based on the nature of and the consequences of what might at first blush be a very simple question, it could have extremely serious consequences. And our mandate as lawyers, and I suppose licensed immigration consultants as well, is that they have to do no harm, and they have to be competent and get the full picture before they can give you formal legal advice. And we don't need to get into details about the cost of running a law practice, but it may be shocking, but we don't make money off of a consultation fee, given the amount of time and per hour it costs to run a law firm. And we're not crying, we're just giving you the context for why we might be kind of brusque if you pose a question to us online or by email. But I encourage the people who answer my emails to at least give a link to something else online, so that it looks like at least you can get steered in the proper direction. So we're coming perilously close to the hour I've allocated here, and I'm scrolling and I don't see any more questions. So I hope this was helpful for you, and maybe if this is posted shortly, then for anybody else who looks us up on YouTube. And I sound like an auctioneer, sort of going, but soon to be gone for this session. But I intend to try to have another session, which we try to promote in advance, usually around the same time. I think it's the third Thursday of each month. So in the meantime, just one sort of thing to keep in mind is if you have a very particular question and you've Googled more than 3 websites about your immigration question, you may want to just get actual legal advice, because if you look on online forums and then maybe look at the IRCC website, which is couched in technical language, and then maybe look at a lawyer's blog, which might have touched upon the question, you may be taking a risk for something which is obviously very important if you're spending the time. And you may want to search out what ostensibly is a technical legal question by getting actual legal advice, right, from a competent immigration lawyer. And we have 3 very good immigration lawyers here. So with that bit of self-promotion, I'll leave it at that. And since we're at 12:59, and enjoy the rest of your day or evening, depending on where you are calling from. Thank you very much. Right. Have a good afternoon or evening. Bye.